Hi everyone, I'm Kelly Longtin from Kelly Longtin Law, and today I'm going to talk to you about how to handle savings bonds in estate planning and at death. See, a savings bond is defined as a debt security issued by the U.S. Department of the Treasury to help pay for the U.S. government's borrowing needs. In effect, when you buy a savings bond, you're loaning the U.S. government money, which is repaid with interest after a fixed period of time. There are currently two types of savings bonds. There's Series EE U.S. savings bonds, and they're currently sold at face value and worth their full value upon redemption and interest. The Series I U.S. savings bonds are inflation indexed. For example, they offer a fixed rate of interest that is adjusted for inflation and are often used as a long-term investment. In Series HH bonds, they're no longer available for purchase. You see, savings bonds are a safe investment and are attractive during periods of economic volatility, as they do not fluctuate in value. However, they are generally not redeemable for at least 5 years, unless you don't mind forfeiting the last 3 months of interest as a penalty. This means that you may not have easy access to the money that's invested in the savings bond. Those who invest in savings bonds can purchase them in increments as low as $25 and as high as $10,000. Now, there's several estate planning issues that you should keep in mind if you have savings bonds or if you do plan to invest in them. A question that gets asked frequently in regards to savings bonds is whether or not they'll have to go through probate. You see, probate is the court-supervised process for proving the validity of a will, if there is one, and ensuring that the deceased person's money and property are transferred to the correct beneficiaries and that any debts or taxes are paid. Now, people often seek to avoid probate as it's time-consuming, expensive, and it's a public process, so anyone can see what's going on with it. Whether a savings bond will have to go through the probate process depends on how it is titled, for example, on how it is owned. So let's take a look at that. Let's talk about if there's only one owner on the savings bond. It's very common for an individual to purchase a savings bond titled in their very own name. However, if you choose to do this, the savings bond will become part of your estate and will have to go through the probate process, even if you have a will specifying who you would like to inherit it. If you do not have a will, the savings bond will be passed on to a beneficiary chosen by the state's intestacy statute. So intestacy statutes are just the state's default estate plan rules for those who don't do any of their own planning. So the state is going to choose your beneficiaries. And sometimes there's a couple of owners on a savings bond. So 2 or more people can hold title to a savings bond as co-owners. Then each of the co-owners is allowed to cash the bond, even without the knowledge or permission of the other owners. Savings bonds titled in this way pass directly to the surviving co-owner or owners without probate. However, when the last owner dies, the savings bonds are part of that person's estate, which now must be probated in the absence of additional estate planning designed to avoid it. You also have the option to name a beneficiary on your savings bond. And this you would do with the U.S. Treasury Department using the Treasury Direct website. If you do this, the savings bond will not need to go through probate because the beneficiary you have named will automatically become the owner upon your death. The beneficiary must also set up a Treasury Direct account, but once that account is established, they'll only need to deal with the straightforward process to transfer ownership of the bond when you have now passed away. The beneficiary designation will even take precedence over a contrary provision that might be in someone's will. This may be fine for some beneficiaries, but it may not be the best course for those who tend to spend money irresponsibly or have lots of creditors that may come after the bonds to satisfy some claims. Another option that one has is to create a trust. If you want to continue to benefit from the savings bond individually without naming a beneficiary with the Treasury Department, but also want to avoid probate, you can create a trust and transfer the title, the ownership of the savings bonds to the trust. Beneficiaries that you name in the trust can receive the benefit of the savings bond, and you can name someone you trust as the trustee to manage the savings bonds. When savings bonds are held by a trust, you can protect beneficiaries who tend to be financially irresponsible from themselves by preventing them from cashing and spending the bonds until the terms of the trust allow them to be distributed to the beneficiaries. In addition, certain types of trusts can protect the savings bonds from being reached by the beneficiary's creditors. And this happens from time to time. What happens if you found savings bonds that belong to someone who has died? A lot of our parents or generations previous, they tended to invest heavily in savings bonds. So this does happen more often than you would think. You see, savings bonds, they can take many years to mature. So they might be stashed in a safety deposit box or a filing cabinet and then forgotten about. The Department of the Treasury has provided instructions about what should be done if the owner of a savings bond has died. If the savings bonds are electronic, the person who died likely has a Treasury Direct account. If so, you should contact the Treasury Department's Bureau of Fiscal Service, which will put a hold on the account and provide instructions for your specific situation. And then other times we have paper savings bonds. For paper savings bonds, you must first determine who owns the bond. A savings bond typically prints the name of the owner or the owners on the bond. If all owners named on the bond have passed away, the bond is part of the estate of the person who died last. In order to properly handle the savings bond, you must establish that you are entitled to the bond or that you have the authority to act on behalf of the beneficiary of the bond. For example, that you've been nominated as the personal representative of the owner's estate or appointed. If the savings bond is part of the owner's estate, the Treasury Department has spelled out several different procedures based on the value of the bonds. Now, if a survivor was named on the savings bond, it does not become part of the deceased person's estate. Rather, the savings bond belongs to the survivor, who can choose to do nothing, redeem the bond, or have it reissued. If the survivor does nothing, the bond will continue to earn interest until the bond matures. The survivor could also cash a paper bond by going to a financial institution that pays the savings bonds and provides the identification and other documentation required by that institution. However, only the Treasury Department can cash the HH series bonds that aren't actually sold anymore. Alternatively, the survivor can have the bond reissued in his or her name alone. The Series EE and I savings bonds are only reissued in electronic form, but they do reissue paper form for the HH bonds. If you own savings bonds or you're considering investing in them as part of your financial plan, we can help you consider the pros and cons, as well as the best ways to title them in order to achieve your estate planning goals. We can also help you determine the best course to follow if you found savings bonds that were owned by your parent or another loved one. So please give us a call today and set up an appointment so we can assist you with this or any other estate planning concerns. We're more than happy to meet with you virtually or by phone if you prefer. So I'm Kelly Longtin from Kelly Longtin Law.